Welcome, everyone. My name is Melissa Pachola, and I'm the Director of Volunteer Services at Legal Aid Chicago. Thank you for attending this training on the Eviction Brief Advice Desk. Today, we'll be talking a little bit about how the desk works, as well as some law. So we'll talk a little bit about what the Eviction Brief Advice Desk is. We'll be covering eviction law and court procedures, including how someone gets evicted and what happens in eviction court. And then we'll spend some more time talking about how the desk actually works and what you do as a volunteer. So before we get into the specifics, let's talk about the problem. There's no question that many of us have heard about the oncoming eviction crisis. We've heard it referred to as a tsunami, as an avalanche, and hopefully you see on your screen the things that likely back up those claims. Something like 500,000 renters in Illinois may be facing eviction. About half of those are going to be Black and Latinx renters in Chicago who are at risk of missing rent. The other big problem that's happening is that there aren't a lot of resources for tenants to get representation. 79% of landlords are typically represented in an eviction action, while only 11% of renters are. An eviction court is unfortunately not always set up in a way that gives people justice. The average length of an eviction trial in Chicago is 104 seconds. And to give you some background, I think I've been talking for more than 104 seconds already. So the problem is immense, and we need your help to try to adjust some of these inequities. Going further, estimates range from about 3,000 to 247,000 Illinois households which will be at risk of eviction in 2021. And to compare that for you, typically in the entire state of Illinois, about 50,000 people are at risk annually of eviction. So batten down the hatches, board up your windows, do the things that we would normally do when we're preparing for a crisis. And one of the things that we're hoping you'll do is volunteer with us to help try to adjust this. So what is the Eviction Brief Advice Desk? The Eviction Brief Advice Desk seeks to provide brief advice to tenants virtually over Zoom. Volunteer attorneys are asked to consult with tenants in Zoom rooms to help tenants understand their rights, review proposed agreed orders from their landlords, actually negotiate on behalf of tenants, as well as make referrals to Legal Aid Chicago for cases where we can provide extended representation. The Eviction Brief Advice Desk, lovingly referred to as EBAD, which I like to say is E-Good, assists tenants from any district in Cook County. Again, volunteers meet with clients in breakout rooms via Zoom, and participation requires brief services only: advice, coaching, a little bit of document preparation. If time permits and you are willing, you can negotiate on behalf of a tenant. And there's no expectations that volunteers will stand up in court or provide full representation in any of these cases. The other thing is we're here for you. Legal Aid Chicago attorneys are virtually on site to provide assistance in every case. So we will see this graphic again, but before we start getting into the basics of eviction law, I wanted you to see sort of an overview of the logistics of the desk so you can see yourself and put yourself in the place where you will be. So this will all start with a referral. A case manager will refer a tenant to services to Legal Aid Chicago. Legal Aid Chicago will conduct a screening and intake to make sure that the client is appropriate for the program and eligible for services. And we'll talk more about those: not landlord, not a foreclosure, not represented. Then at that point, assuming that everything looks good, the case will be assigned to a volunteer like you And we'll do our best to make sure that there are no known conflicts ahead of time before we assign a volunteer to you. Again, and that would be a conflict with you, the volunteer, not a conflict with Legal Aid Chicago. The volunteer will then interview the client and provide the brief services that are necessary, whether that's referral, negotiation, just advice. And then after your shift, you'll send your notes to Legal Aid Chicago so we know what happened with that case. So now that we've sort of just basically introduced what this is and how it works, we're going to dig in and we're going to talk a lot about eviction law. And I mean relatively a lot. I'm not going to cover everything that could happen in eviction court, but my goal is to give you the basics of how an eviction works so you can put it in context when consulting with the tenant. And we're going to talk about court procedure as well. My goal, of course, is not to overwhelm you. It is not to make you feel like you can't do this if you're not an expert in eviction law. And I'm not expecting that you will be. Again, I'm covering the basics here today, not the specifics, and the goal is to make you feel confident to be able to volunteer. So speaking of confidence, this chart is intended to erode your confidence and make you feel overwhelmed as to the number of laws at work. And of course, I'm joking. What we're trying to do here is lay out that there's a couple of laws that interact with each other in eviction court and that provide collectively the rights of tenants. There's some federal laws that provide the basics for when a tenant could be potentially have a claim of discrimination or seek protection as a victim of domestic violence. The two laws that often correspond and overlap amongst each other are the Eviction Act, which is a state law, and the Residential Landlord Tenant Ordinance, which is a municipal law in Chicago. And we'll talk as well as about the Cook County Residential Landlord Tenant Ordinance. But I like to put these sites here so that if you're ever wondering where the law comes from, you can take a look, maybe put yourself to sleep by reading the entirety of the Retaliatory Eviction Act, which by the way is only a paragraph. So if you fall asleep after a paragraph, I have questions. But just to say that here's the backbones of what we're working with. In most cases, I am not expecting you to have to refer to the law to be able to advise a tenant, but we'll talk a little bit more in particular about where these rights come from and in particular about what some of them are. So we made reference to the Chicago Residential Landlord Tenant Ordinance. If you're lucky, you can get a peach copy of it. It's also known as the Rlto. Some people call it Rlto, and I don't know what to say about that except for you should call it the Rlto. The purpose of the Rlto is to protect tenants and preserve housing. And just like every law, there are certain types of places it applies and certain types of places it does not. So here, generally in Chicago, if it's an owner-occupied building, right, the owner lives there full-time or close to full-time, and there are less than 6 units, the Rlto does not typically apply. However, the lockout protections and provisions apply to every dwelling in the city of Chicago, including owner-occupied units. The other exceptions are, of course, things that are not places where you would establish a tenancy, like a hospital, like a dorm room where there are exceptions. So for the most part, we can assume that it applies except for the owner-occupied or if something else strange is going on. There's also the Cook County Residential Landlord Tenant Ordinance. And this is a law where most of the provisions are going to be effective on June 1st, 2021. Of course, the lockout provisions are actually effective now. And it extends many of those Chicago Rlto protections to tenants in suburban Cook County. Similarly, there are exceptions, does not apply to owner-occupied units, but it creates a lot of those rights that typically only Chicago tenants had, such as the ability to withhold rent for conditions issues, protecting against lease terms that required tenants to waive their rights, providing some protections against outrageous late payments and late charges, and then also providing some backbones of what a security deposit looked like, and then the very popular move-in fee, which has largely replaced the security deposit in many situations. So again, the Cook County Residential Landlord Tenant Ordinance, most of the provisions are coming and they will be effective as of June 1st, 2021. The lockouts are effective now. And so we won't be talking at length about the provisions of the Cook County Residential Landlord Tenant Ordinance, but just to say that it's out there and will be effective June 1st. There's a couple other laws, of course. There's the Eviction Act, which governs how eviction cases work, how they start, what kind of notice people are entitled to, and importantly, contains what we call the right to trial by jury, right? It basically says that anyone, either party, can demand a trial by jury in an eviction case, and that it really is an important right for tenants and people representing tenants. And then Evanston and actually Mount Prospect have their own local residential landlord tenant ordinance. We specifically call out Evanston here because it's a more populous area. And it's similar to the Rlto, but provides a couple of different notice periods for clients who might be living there. One of the biggest things that comes up when you're talking about tenant advocacy, and in particular for the Eviction Brief Advice Desk, is the differences between someone who's living in subsidized housing or private housing. So subsidized housing includes what we would traditionally call public housing, housing that is owned or operated by the Chicago Housing Authority. If we hearken back in time, those big housing projects that where a lot of low-income people were sort of concentrated, that's our traditional public housing. But there's also all other types of subsidized housing. Popularly, you may refer to people saying that they have Section 8, a Section 8 voucher that they're actually using to rent in the private market at a reduced rate. And then other types of rental assistance. Maybe somebody receives something called the Low Income Housing Trust Fund, which has a fun acronym that nobody can say, but is out there and has its own rules. So for your purposes, typically by the time a tenant comes to you, we'll have determined whether or not they are actually living in subsidized housing. And if they are living in subsidized housing, we likely will have made a referral internally to Legal Aid Chicago. But just in case, how do you determine if a tenant is subsidized? So a lot of times, again, the plaintiff, the landlord, will often be listed as the Chicago Housing Authority. But there's also a number of property management companies that CHA contracts with to manage properties. And so it's not always a dead giveaway that if it's not CHA, it's not subsidized. But the other big one is that the rent paid by the tenant is going to be lower than market rate, right? So something like $340 a month for a 3-bedroom. Well, in the city of Chicago, that's not exactly market rate. And I don't know how many of you are renters, but I'm going to guess that your bells are going off like, wow, that's a good deal, right? It's because there's rental assistance flowing to the property. The other best way to know, ask the tenant, right? Are you receiving any type of rental assistance? Is often how I ask people that question. Sometimes when you ask people if they have a subsidy, they won't often respond positively because that's a word that isn't familiar to them. But asking them, do you have Section 8? Do you receive any rental assistance? Might get to the root of the issue there, as well as asking them, is your rent calculated according to your income? That's often a thing that will tip people off that actually they have a subsidy. The reason this is so important to sort out is because really, if you're receiving rental assistance, then in most cases you can't afford to rent on the private market. And so if you lose that subsidy, you're likely to become homeless. But the other reason is because there are rules associated with living in subsidized housing. And if you are evicted from subsidized housing, you likely will never be eligible to live in subsidized housing again, right? So you'll be barred from receiving a subsidy if you're evicted from your current situation. So therefore, Legal Aid Chicago prioritizes representing subsidized tenants in their eviction cases. And so if you are talking to somebody and it becomes clear to you that they have a subsidy, or even if you have a question as to whether they have a subsidy, you should alert us, and most likely we'll be referring that case internally for representation. This graphic lays out sort of the timeline of an eviction case, and we'll be talking about each of these steps in detail. So I'm not going to go into too much depth here, but generally there are 6 steps. It starts with service of something called a termination notice that in writing terminates the tenancy. After the expiration of the notice, the landlord can file a case in court, and then the tenant has the right to be served with summons, notifying them of the fact that there's an eviction pending. The client has the right to appear in court. And at that time, typically cases are resolved before trial by agreement, just like most litigation. If there's not an agreement, it'll go to trial, or maybe there'll be a compliance status on the status of the settlement. And then if the client is evicted, if there's an eviction order entered, the sheriff is the only one who can come out and execute the eviction, right? That's that last step of an eviction that will include a big orange sticker on the door. And we're not going to talk too much in detail about this provision, so I want to say it now. If an eviction order is entered, only the sheriff can execute, not the landlord. So typically, even if the tenant loses at trial, the sheriff still has to come out and enforce that. The landlord can't self-help by changing the locks after they have that signed order from the judge. The sheriff has to come out and execute. And you'll see in red here that we're going to provide you an additional handout that has some additional protections extended to the tenant as a result of COVID-19 and may impact their rights. And we'll get into some of them, but we also want to provide an additional handout because I'm not expecting you to remember everything that is discussed here. So let's talk about step 1, a termination notice. And one thing I want to say right now is that a termination notice can be served by the landlord, a property manager. It can be served by the property manager's brother. We've had situations where a neighbor serves a termination notice on the client. It can be the landlord or the landlord's representative. And it doesn't have to be somebody who's licensed by the court. It does not have to be a sheriff who serves a termination notice. So what are the types of termination notices that exist? The most common is a 5-day notice for non-payment of rent, right? So if you are behind on rent and your landlord is seeking to terminate the tenancy because of that, they have to give you a 5-day notice. The 5-day notice actually gives you those 5 days to cure. So if I was behind on my rent and my landlord gave me a 5-day notice and I could use my stimulus check to pay all of the rent that was owed within those 5 days, I can pay my landlord, and then the landlord cannot proceed to file an eviction case because I've cured the non-payment of rent. One thing to caution here, and things that often come up, is if I receive a 5-day notice and the 5-day notice is demanding $1,500, for example, and I go to my landlord within the 5 days, but I only have $1,000, the landlord can take the $1,000 from me and still file an eviction case. And that's because most 5-day notices will include language that says something to the effect of only full payment of the amount demanded will cure this notice. So typically, if I'm advising a tenant and they tell me they have some money, but not the entire amount, I tell them to keep that money unless there's an agreement in writing that the landlord will accept less than the full payment. So if you have a situation where a tenant says, I gave partial payment after the 5-day notice, it's typically not a defense to the eviction action. A 10-day notice is a little less common, but it's basically for lease provisions that have been breached, right? And here on this slide, I should say, I've got laid out in these bullet points sort of what each notice must contain. You'll see that they're very similar about, it has to include the address, it has to include the date that it was given, etc. But a 10-day notice also has to include information about the lease provision that was breached. And case law has said that that breach must be material, right? So it must be something that matters. I once did have a case where the client had a 10-day notice for slugs in the washing machine, right? So she had put coins that were not coins in the washing machine, often referred to as a slug instead of a nickel or a quarter. And they were trying to evict her because they claimed that that was a violation of the lease. But the landlord has to attach, both the provisions of the lease that have been breached and some description of what the tenant did to breach it. And the tenant has the right to say, hey, within those 10 days, dear landlord, I would like to cure this breach. And again, you only have the right to cure if it can be cured. So if, for example, you're being evicted because you started a fire that did damage, it's difficult to cure that because it happened in the past. But if you're being evicted because a guest of yours caused a disturbance, you may be able to cure that by saying, I will not allow that guest to visit me anymore. You'll put them on what's known as a bar list, which is a common remedy in situations of a 10-day for behavior of somebody, including a guest. The other type of notice is a 30-day notice or a non-renewal no cause notice. I like to call these, I don't like your face evictions, which is, you didn't do anything wrong, but I no longer want you to live here. And the way to analyze these is often, you can't evict somebody for a bad reason, but you could evict them for no reason, right? So a 30-day notice can say it's either a non-renewal of a lease or just like, I don't want you here anymore. The biggest thing to know here is that the 30-day notice cannot terminate the lease in the middle of a rental period. So you can't give somebody a notice on, for example, March 15th to terminate their tenancy on April 15th, even though that's more than 30 days. You have to give them the full rental period. So if you get a 30-day case, you should consult with the legal aid supervisor to make sure that the tenant has been properly given notice. These are tricky and a lot of landlords screw it up. If you're dealing with somebody who has a 90-day notice, you should consult with legal aid. Typically, those are cases where there's a foreclosure pending or it's subsidized, or there's another Chicago fair notice situation at play here. So how do I get a termination notice? I already mentioned that the landlord can serve the termination notice himself, not him or herself, not the sheriff. So who can get it? You can knock on the door, hope to find your renter, Tanya Tenant, and serve personally. You can serve with someone who's 13 or older who resides in the property. So big one here is that technically a termination notice should not be given to somebody who's just visiting. You can send it by mail as long as you do it by certified or registered mail with return receipt. And you can also serve it by posting, which is putting it on someone's door or sliding it under the door. And there actually are rules for posting. But let's talk about the improper service allegedly of the notice. So there's a case out there that says if a tenant was living in the property, then you can't have served by posting because you should have tried harder to find them. However, that case has been overruled. There's a couple of subsequent decisions, and the law seems to now state that the tenant's receipt of a posted notice is sufficient. But the landlord is still required to prove substantial compliance with how they tried to serve the tenant. So the landlord has to say, hey, I tried, I knocked on the door, and then I slid it under the door. Or, I tried to find her 3 times, she was never home. So this is kind of tricky because a lot of tenants will come to you and say, it was posted on my door, I know that's not right, and therefore I can't be evicted. And your ability to enforce that right in eviction court is shaky at best. So although the law says, you should be receiving personal service of the notice, oftentimes if the tenant discovered the notice on the door, it's going to be sufficient. The other types of notice-related issues and defenses, and again, we've laid out this for you in a checklist so you can consult it and not have to memorize all of the notice issues that may occur. The tenant may say, I never got a termination notice. Just so you know, the landlord almost always will say, yep, I served a termination notice. And as we'll talk about in a second, the notice is now required to be attached to the eviction complaint. So this used to be a really good defense. If the tenant could really say they hadn't received it, it may still be a defense, but it's trickier when the landlord has filed the complaint, attached the notice, and signed an affidavit saying they served it. There are times when the notice will be defective, right? So maybe the landlord calculated wrong and they didn't count weekends or did count weekends improperly on the cure date of the 5-day notice. But of course, a non-renewal notice that even on its face may not give the tenant enough time may still be considered good if the case isn't filed prematurely, right? So if the landlord actually waited until 5 days later to file the eviction action and the tenant still hasn't cured, then it may not matter that the notice was facially defective. Again, premature filing is filing before the expiration of the notice or cure period. And that's often where it comes up that the tenant wasn't given enough time to cure. Counting days, particularly of service, can be tricky. So that's why we've provided you the procedural issues checklist. And if you think you've got an issue there with a notice, you should alert the Legal Aid Chicago attorney who's on the Zoom. So after the notice, we move on to step 2, which is the landlord will file an eviction complaint. So let's talk. A landlord can file the eviction case after the notice or cure period expires, unless barred by a moratorium, which of course we'll talk about in detail. Landlord will typically name any adult who lives at the property as well as unknown occupants, which is basically the landlord's way to say anyone else who's living there can't be living there. I want everybody out. The landlord can file a single action, which is only seeking possession of the property, or an action which is seeking possession plus back rent owed. Most evictions are joint actions. Here is a very fancy eviction complaint, which is the one that everybody uses. The requirements for what is to be an eviction complaint is actually pretty simple. Hey, I own this place. I'm entitled to possession. Defendant has unlawfully withheld possession from me, and they owe me rent. Very simple complaints, typically very difficult, for example, to dismiss a case based on deficiency of the complaint, unlike in some other settings. However, after July 27, 2020, the complaint must actually attach the termination notice, plus an affidavit saying that it was served to the eviction complaint. So if the notice is not attached, then the tenant can actually ask for the case to be dismissed. If for some reason there was not an eviction notice or it was lost, they have to attach an affidavit that it was served or something else is going on. And again, if it's a for cause, like for a lease violation, the landlord also has to attach a copy of the lease, including the provisions that were allegedly breached. So this is a rule actually that makes advocating for tenants in eviction court a little simpler, because we now can see the notice that is attached to the complaint as opposed to wondering if it's out there somewhere and the landlord might be holding it. Prior to this rule, you kind of had to wait until discovery to get a copy of the notice. Now it's attached to the complaint and we can see what was happening there. After the case is filed, there's service of summons. So this service is similar to how service in any case occurs, right? So you're entitled to be provided notice of a lawsuit filed against you, regardless of the type of lawsuit, just like in same thing in an eviction. So in Cook County, in particular, the landlord has to first attempt to serve using the Cook County Sheriff, and then a licensed special process server can be appointed upon motion and order by the court. This is the one, the summons is the one that you can ask if the client was served by a sheriff or not. And there are 3 methods here that are very similar to the methods of the service of the termination notice: personal service, substitute service. Again, one little wrinkle here is in this case, a family member can be served even if they don't reside there. So this is the classic mother-in-law watches the kids but doesn't live there. Knock, knock, knock on the door. Sheriff serves them with summons. That's a valid method of service. And there's also constructive service, which is posting or public. One thing to note here is that it's only permitted after sufficient attempts at personal service or substitute service, and the judge has to give permission. The other big thing here is that if a tenant has not been personally or substitute service, no money judgment can be entered unless the defendant shows up and submits to the jurisdiction of the court. So you'd be surprised at how many tenants show up to eviction court even though they haven't been served. And it may be worth talking to them about whether or not they want to submit to jurisdiction, depending on whether or not money is at stake. So it's not a no-brainer that if you find out about a lawsuit, you're going to want to participate because of this provision that without personal jurisdiction, no money judgment can be issued. Again, we provide you a checklist so that you can remind yourself about whether or not there's going to be issues with service, and if you should be raising those in representing the tenant in a negotiation, for example. After we get our summons served, we've got court, we've got to appear. So after being served a summons, a tenant must appear in court, or an ex parte or a default eviction order may be entered against them. This picture on here is a picture of one of the courtrooms in eviction court, which many of us in the Daily Center, which many of us have not seen in many months, but there it is. So pro se tenants will appear remotely via Zoom on the return date and may be asked to refer to something known as the Early Resolution Program, which is what the Eviction Brief Advice Desk is a part of, which is managed by a case manager. So bottom line, pro se tenants on their first court appearance can ask for a referral to legal aid. That's the easiest way to think about that. And that's how cases are going to be coming to you. Tenant's going to show up in court. They're going to have a conversation with the judge. They're going to talk a little bit to the case manager, and then eventually they'll be referred to us. I previewed this, service issues. So even if the landlord has not done what they're supposed to do, if there's no service, but the tenant steps up, sort of says, hey, I'm here, even in a Zoom hearing saying, unmute myself, I'm here for this case, they can risk submitting to the jurisdiction of the court. And if a tenant lives in a property but isn't named, stepping up in front of the judge may result in the judge going, excuse me, what's your name? Or the plaintiff's counsel more likely being, excuse me, what's your name? You're living in the property? Judge, can I have leave to file an amended complaint and add this person? So there are risks there with submitting to the jurisdiction of the court and attending a court date if you haven't received proper service that we want to point out because they often do come up with questions from tenants. So what are the tenant's options at that initial case management date? So if both parties are unrepresented, the landlord does not have an attorney, if the tenant does not have an attorney, the judge and the case manager will be asking them, would you like to resolve this? And would you like to resolve this with the help of a neutral arbiter or mediator? And if they say yes, they'll go to mediation to try to work this out. If the landlord has an attorney, the tenant can ask to be referred to legal aid. And then the tenant has additional options. They can negotiate, they could seek additional legal assistance or representation before the next court date. They could file a jury demand, or they could go to trial. And on any other date than that initial case management date, we need to know what happened last time to figure out what the tenant's options are. So we're not going to spend a lot of time talking about how an eviction trial works, because again, just like in most litigation, we'll probably be trying to avoid it. But evictions are what's known as summary proceedings, which some people confuse with the idea that there should be no discovery or really any due process. And that's just not right, which is why we pointed out here. You have the right to discovery in an eviction case, even if you're the defendant. You have the right to review the plaintiff's evidence, to present your own evidence, and to examine witnesses. Bottom line, most cases are resolved through agreed orders, including agreed eviction orders or move out and pay and stay agreements, also known as payment plans. And most landlords' attorneys will pressure tenants to settle, to sort of resolve this. And so will some judges. Judges will want to see these cases resolved without having to conduct a trial. So what are options for negotiating and settling? What are the things that are at stake here? So basically these fall into two categories. Is the tenant moving or is the tenant staying? So if the tenant wants to move, they can agree to move out by a certain date in exchange for a waiver of back due rent, for example. Case should be dismissed after a tenant moves out, because if possession is no longer at issue, the eviction should no longer continue. And if the tenant has a pretty strong defense, maybe they never got a notice, maybe they have a very strong counterclaim, which we'll talk about counterclaims, they may be able to get a cash settlement to help them move. They may be able to get more of that back rent waived, additional time to move, or maybe even all three. And there is a standard court form to use to memorialize agreed orders, and that is provided to you as well. The other type of deal that is the most common in eviction court is what we call a pay and stay, right? If the tenant wants to stay, they're going to need money to pay, assuming that the issue, of course, in the eviction is back rent, which it often is. The tenant has money to pay rent and can pay going forward, or is willing to apply for rental assistance, or knows that rental assistance is coming and is pretty sure that they're going to get it. It might be possible to get that kind of agreement. If you're writing an agreement that's the basis for rental assistance, or is going to be contingent on the tenant receiving rental assistance, then that should be spelled out pretty clearly. And then, of course, sometimes people get tripped up on the actual mechanics of how to comply with an agreement. Who am I paying? How much? To whom? All of that. And negotiating these agreements can be difficult if the tenant and the landlord cannot agree about how much money is actually due, right? Tenant says, I paid October. Landlord says, I have no record of you paying October and I want October rent. Things can get sticky. The other big thing is that once a case has been filed, particularly if the landlord is represented, typically that attorney is going to want attorney's fees as well as court costs, because it's not free to file a case. So being able to wrap up those costs may be an issue, and we'll talk a little bit more about that. So when thinking about a deal, and this is something that if you're willing to negotiate on behalf of a tenant, you'll have to think about, but also to advise tenants. You want an agreement and not an eviction order. You also want to understand what's out there. Can the client move? How much time? Do they have the money to pay? Can they include court costs? You are, of course, welcome to review any proposed orders with the client. And you can even draft the agreed order. And we've, again, provided samples for you. You can also coach the client through how to ask for sealing and help them fill out the sealing order. What is sealing? Sealing the record is suppressing the record from public view so that nobody can see it. Basically, have the ability to pick up the filing of an eviction case, and landlords, prospective landlords, often run reports from tenant screening agencies when tenants apply to rent an apartment. And if an eviction case shows up, they will not rent to that person. So that is one of the biggest consequences of having an eviction on your record, is that you'll be very, very challenged to rent in the future and often to move at that point. An eviction case can be sealed or may be sealed on a discretionary basis by the judge if it is sufficiently without a basis in fact or law and the interests of justice outweigh the public's interest, okay? So practically, that's the law. Practically, many judges will seal the case if the landlord does not object or the parties agreed. Also, the judge might still ask the tenant, like, well, what's the basis for this? How is this going to harm you? There is a separate sealing order that has to be entered by the court, and we provided a sample of that in your materials. And just for everyone's, there is something called mandatory sealing, which is in a post-foreclosure action, either from a tenant or an owner, they're automatically sealed. They're always suppressed from public view. So sealing can be an important bargaining chip in negotiating, and also really important to the ability for the tenant to rent in the future. Thinking about what actually goes in an agreed order, again, will the tenant move? Will they stay? When the tenant will pay rent, what constitutes a breach of the agreement and the consequences for that breach. A headline, the consequence for a breach of the agreement is almost always the immediate entry of an eviction order. Is anyone waiving any claims? Either the defendant or the tenant. Maybe the plaintiff is waiving the right to keep the security deposit. Maybe the tenant is waiving their right to enforce any counterclaims. A compliance status date, if you're coming back to court to see if everybody complied. Are you sealing the file? And again, if there's a provision to reinstate the case, how long does that last? So oftentimes in a payment plan agreement, you'll come back, you'll dismiss the case, but sort of say, okay, if you don't pay, we can reinstate the case for 6 months. Dismissal pursuant to a pay instate. I want to talk just for a second about jury trials and how you request a jury. So I mentioned already, parties in eviction actions have the right to request a jury. The timing of this is that a tenant must file the jury demand before the first court appearance, or their right to the jury is deemed waived. If you're talking to somebody and it seems like they're going to want to or need to file a jury demand, you should advise them to do it as soon as possible. Once a tenant files the jury demand, the case will be transferred out of eviction court and assigned to a new courtroom with a different court date. And of course, information on how to file a jury demand and a client handout are in your materials. And of course, you can consult with the legal aid attorneys about further questions about that when you're advising a client. We're going to talk next about defenses and counterclaims. Let's think about all of these in context, though. Your role as the volunteer attorney is to help identify potential defenses and counterclaims in your interview with the client and your review of the documents. And you can consult with legal aid on the strength of those defenses. Often, without going to trial or a contested hearing with an attorney, a tenant will not win their case because of a potential defense. Often, sometimes they can be the basis of a referral for extended representation to someone who might represent the client, but most often they're useful leverage in negotiation and settlement, right? So very rarely will a tenant raise a defense with you and then we'll say, absolute winner, no worries, tenant should go back to court and explain that to the judge and everything's going to be fine. It's often a little bit more complicated than that. So let's talk about some of those defenses. This slide is gross. Yes, it is. You know why? Because roaches are gross and so are conditions issues. Many, many, many tenants will talk to you about the disrepair of their apartment. They will tell you about all of the things that the landlord did not fix. The place was gross. I can't believe they lived there. Two potential defenses here as of right now. There's something called the implied warranty of habitability, which the tenant can assert as an affirmative defense, basically to say, this place was so awful, it wasn't worth the rent that is being asked of me, right? So I had no heat for 2 months, so the amount of rent that I should have had to pay was 0. This does not kick in automatically. The landlord still has to be on notice. The landlord has to be given an opportunity to repair and not take it. And the reduced value of the property has to exceed back rent. So even if you were living with all of these roaches, I have seen judges hold, yeah, that's bad, but it doesn't make the rent value 0. In Chicago, under the Rlto, there is also a provision to withhold rent or to be able to put your landlord on notice of these issues and have a defense. Again, it's coming for the Cook County residents. But the tenant has to have done everything right. They have to provide a 14-day, typically, written notice for regular issues and a 24-hour written notice for basically no heat and those kind of things. And they have to provide the landlord the right to come in and repair it. If they haven't done those things exactly right, withholding rent may not be appropriate and may end up not being a defense. Outside of Chicago, there's also something called the Residential Tenants Right to Repair Act, which is basically like you give your landlord notice. You say, if you don't repair this, I'll do it myself. Then you do it yourself and you can deduct from the receipt, from the rent, the amount that you paid to do it. But again, that's still only if it's less than half the rent, the cost, or $500. It's not a total defense to not paying rent, unfortunately. What other kind of defenses do they have? Conditions are a big one. Waiver is another one that might come up where, the landlord gave the tenant a termination notice, but then later came to them with a new lease. This sometimes actually happens where there's rental assistance involved, where the rental assistance requires the execution of a new lease. So the landlord won't think twice about it, sign the new lease, and then still try to file an eviction case. So that would be a defense known as waiver. If you gave rent and the check was cashed, or you can prove that the rent was accepted, then you also may have a defense there. If during the cure period, the tenant has tried to pay, but the landlord refused it, there may be a defense there. And in Chicago, tenants have the right to cure the non-payment up until the enforcement of the eviction order, and then the eviction can actually be dismissed. There's also retaliation, which is that the landlord takes some kind of a adverse action, most often filing an eviction, after the tenant does something that it would be considered protected, like requesting a repair, like calling 311, like writing a letter. Retaliation is a decent defense. Again, to enforce it without an attorney is tricky because it's similar to a discrimination where the landlord can say, that's not why I was evicting them. I was evicting them because they owe me $10,000 in rent. I didn't mind that they asked for a repair. That's not what this is about. So it's a defense to flag. It may not be a total winner in the eviction action. Other things that happen to tenants, lockouts, right? We talked about this a little bit before. A landlord cannot knowingly lock out a tenant by changing the locks. We have seen a lot of, I'm going to shut off your utilities to force you out. Unlawful entry, which is that, the landlord keeps entering without permission. Tenant's got to have proof of this. And a lot of times the proof that the tenant has is, I think it happened. So that can be challenging. Something known as a utility tap, which is a tenant has proof that they're paying for common areas of utilities. And then security deposit violations. And I just want to say here, you can use a security deposit violation as leverage. It's actually not germane to the eviction case, so you could not file an answer with this counterclaim. Again, if you want to enforce the security deposit violation, you actually have to file a separate lawsuit. So it's out there. It can be a potential defense in terms of using it as leverage. It can't be pled in front of the judge. All right. Moratoria, which is one of my favorite words that I say so much. So if you clicked on this training, then I'm assuming you realize that there are exceptions to the moratoria and people are still being evicted. But many people think that nothing can happen now because of the moratorium. And we're going to get into this. So since April, there have been several local, state, and federal orders that prohibit or prevent eviction actions. They're not the absolute bar that they may seem to be, and each case needs to be reviewed in detail. So to determine whether or not the moratorium provided defense requires a two-step inquiry. When was notice given and when was the case filed? But if you have a case that was filed prior to the enactment of the original state moratorium, which went into effect April 23rd, you should notify Legal Aid Chicago and consult with them on next steps, because in most cases, the moratorium doesn't apply at all. So when was notice given? If it was given between April 23rd and November 13th, the executive order arguably prohibited landlords from issuing termination notices during that time period. And this could be the result, end up in a dismissal, but most likely is going to end up being leverage. If an eviction notice was given to a Chicago tenant after March 21st, the landlord was required to also serve the tenant a notice of COVID impact at the time of giving a notice, and sort of triggers a 7-day negotiation period. If the landlord didn't properly give that notice, the case should be dismissed. And if the landlord did give the tenant the notice, you should ask about what happened with negotiation and then consult with a legal aid attorney. If the notice was given after November 13th, ask the tenant whether the landlord also gave a declaration form before giving them the termination notice, something known as a tenant declaration form. The declaration requires the tenant to swear under penalty of perjury that they're unable to make payments, that they were making best efforts, and that if evicted, they'd be homeless. The landlord's required to provide a copy prior to issuing a termination notice or filing a case. And the case should be dismissed if the landlord fails to provide the declaration or gives the tenant a termination notice, or if the files the case despite the tenant returning the declaration. So here is the declaration form. You'll see there that it requires a single signature from the client. They don't have to circle what applies. They don't have to explain their circumstances in detail. They need to sign it and date it. Okay, this has to be given in every case filed post November 13th. The other thing to note is when the case was filed. If the case was filed between April 23rd and November 13th, the case should not have been filed unless there's a health and safety exception alleged. If you've got one of those, consult with a legal aid attorney. If the case was filed after November 13th, ask the tenant whether they got the declaration, ask if they returned it. Any case filed after November 13th where the declaration wasn't provided should be dismissed. And any case where the tenant returned the declaration to the landlord at any point should also be dismissed. So let's look at what's going on here. Between April 23rd and November 13th, the only actions that could be filed were health and safety violations, right? And the eviction moratorium lays out in particular what is a health and safety violation. After November 13th, cases where the landlord received a declaration can't be filed. But other than that, everything can be filed. right? So only where the declaration then, basically the moratorium only kicks in if the tenant properly provided a declaration. If an eviction was already entered against the client and it was entered between April 23rd and December 31st, there's a prohibition on entering eviction orders unless it's based on the health and safety exception. If you have a case like that, consult with the legal aid supervisor, as there may be an opportunity to file a motion to vacate. Okay, so let's take a deep breath. That was the law in a very, very short time period, in a relatively small nutshell. And now we're going to talk a little bit more about how the eviction brief advice desk works. We've talked about some of this, but we're going to overview it again. Take a deep breath. What is your volunteer responsibilities? You're going to review court documents, notices, post settlements. You're going to provide clients with information about the court process, settlement options, and referrals to attorneys. You're going to send case notes, and you may negotiate on the tenant's behalf. Not required, but you may. Those are your responsibilities. Remember our chart? These cool little arrows? Let's go through them again. Starts with a referral, right? A case manager sends a tenant who has asked to be referred to the early resolution program to us. Our staff do an intake and make sure the client's eligible. They also make sure that it wasn't accidentally a landlord. We don't advise those, that they don't own their own house, that it's not related to foreclosure, and that the tenant is not already represented. The case will then be assigned to you, again, in a breakout room where we don't believe you have a conflict with the plaintiff or the defendant, and we can only do that if you tell us in advance what would be a known conflict with you. A known conflict, of course, relates to the Supreme Court rule that allows you to provide brief services unless there's a known conflict. You will then do a client interview and provide the brief services. You will interview the client and maybe do some referrals or negotiation. And then you'll send us your notes so we know what happened. All right, so when you log on to your Zoom, you'll be assigned to a breakout room. You'll then be alerted when there's a tenant ready to speak to you. The help desk host will provide you with all of the documents that we were able to obtain. It's not a perfect system virtually, so we'll do our best to see what we can get for you in advance. And we'll try to provide it to you in advance of your shift if we can. We'll also provide a link to the court docket, which has limited information on the case, but importantly can tell you when it was filed and who is representing the landlord, if anybody. We can also let you know if we have any other information, such as, hey, this person is interested in mediation, the landlord is, or the landlord said they'd settle. You can take a short time to review those documents if they're provided to you in the Zoom, but we do want you to not take forever because you got to meet with your tenant. So the tenant will then be sent to your breakout room. And you'll start by going over what we call the statement of understanding, which is provided in your materials and lays out the relationship and makes clear that we have not agreed to represent the client. You'll note the client's verbal consent to the statement of understanding in your notes. You'll then proceed with the interview, and guess what? You'll get a checklist. But your main goal is, what does the client want? Have they attempted to negotiate? Do they want to negotiate? And are there any potential defenses? You'll also decide in consultation with the legal aid attorney whether or not this is a case that's probably good for legal aid Chicago representation. So for some reason, a client with a voucher or living in subsidized housing ends up with you, you'll want to flag that. And another category of cases that Legal Aid Chicago is interested in is if the client is facing sexual harassment from their landlord. Again, those will probably be screened before they get to you, but just in case the tenant raises something in their interview with you, you should know that. After you're done gathering facts, you'll leave that cozy breakout room and you'll consult with an attorney from Legal Aid Chicago about your next steps. In most cases, as alluded to earlier, there's sort of 4 options here. Provide advice. You might make a deal, either through negotiation or mediation. You might make a referral for extended representation somewhere other than Legal Aid Chicago, and we can provide the referral numbers and other options for the client. Or you might tell the client, return to the next court date before the judge for litigation, and you should advise the tenant to file a jury demand in those cases. If you and the client want to negotiate with the landlord, you can identify the plaintiff by looking at the docket or examining the complaint, which should have the plaintiff's phone number. If you call the attorney to negotiate or the pro se plaintiff to negotiate and there's no answer, you can actually leave the phone number of the legal aid attorney for a callback. We don't want you to have to be answering these calls when you're doing other things. If you're unable to locate the contact information and you feel like it's a strong case for negotiation, you'll let us, Legal Aid Chicago, know that by letting the supervisor or attorney know and making a notation in your notes, and we'll probably pick up that case. And if you feel like you're not really sure it's a strong case for negotiation, you can provide guidance to the client on their next steps and also give them the option to contact the Center for Conflict Resolution for potential mediation. So how do you volunteer? You can sign up for a shift on the Sign Up Genius, which will be made available to you. You will be then sent login information and additional materials the day before your shifts. Shifts are going to be available every day of the week, and all shifts are going to last about 2 to 3 hours. They may end sooner depending on the number of clients seen. They may take a little bit longer if you're in the middle of a negotiation, which of course, if your schedule does not allow for it, you'll let us know. So let's do this together. We're going to be there to support you. We'll have paralegals, we'll have vistas, we'll have attorneys to answer your questions and help you work with the client. You'll be able to gain experience in client counseling and negotiation. And of course, by giving advice to renters or negotiating on their behalf, you can empower them to self-advocate, connect them with needed legal assistance, and help them to stabilize their housing. This is my contact information. You're welcome to reach out directly to me with questions about how to volunteer. If anything that I've said in this causes you to say, excuse me, send me an email. I'm happy to talk with you about it. And then finally, thank you so much for attending. It's been a pleasure to do this.